Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.
People v. Travis Woods. Decided on April 21st, 2026. Rivera. 3 juries deadlocked and failed to convict defendant on murder and criminal weapon possession charges. The prosecution retried defendant within months after each of the first 2 trials, but then delayed more than 3 years before proceeding with the 4th trial. We agree with defendant that the prosecution failed to justify this final lengthy delay, instead offering vague and unsubstantiated claims that this time was needed to assess whether to dismiss the charges or try the case again. Therefore, defendant's murder and weapon possession charges must be dismissed. However, we reject defendant's challenge to his conviction on drug-related charges at his first trial based on the trial court's failure to provide defendant notice of 2 jury notes asking for the testimony of certain witnesses. That error does not warrant reversal, because on the very next day of trial, the jury sent another note requesting the same testimony from the same 2 witnesses, and defense counsel read this note and participated in choosing the testimony that was read back to the jury. 1. Defendant Travis Woods was initially tried in 2008 on charges of second-degree murder for the 2006 fatal shooting of Barry Miller and second- and third-degree criminal possession of a weapon based on that shooting. He also faced charges for the attempted murder of Jermaine Gordon, first-degree assault, and second- and third-degree criminal possession of a weapon. Finally, defendant was also tried on drug-related charges, including criminal sale of a controlled substance in or near school grounds and 4th-degree criminal sale of a controlled substance. In October 2008, a jury convicted defendant of the drug-related charges and acquitted him of the charges relating to the Gordon shooting, including the attempted murder count. However, the court declared a mistrial on the Miller murder and criminal weapon possession charges after the jury deadlocked on those counts. In January 2009, defendant was sentenced on the drug counts to a 9-year aggregate prison term. The jury again deadlocked on the murder and weapon possession charges after the next 2 retrials in April of 2009 and 2010, resulting in 2 more mistrials. On April 29, 2013, defendant moved to dismiss the indictment on speedy trial grounds. The trial court denied the motion on June 4, 2013, and the 4th trial commenced that same day. The following brief chronology of events between the 3rd and 4th trials is undisputed. Of the approximately 20 calendar calls when at least one party appeared during the 3 years of delay, the prosecution failed to appear, despite defense counsel's presence, at least 6 times, and requested an adjournment through a stand-in prosecutor at least 5 times. On other occasions, a stand-in prosecutor appeared with little information about the status of the case and without requesting an adjournment on the record. At a calendar call on September 10, 2010, approximately 4 months after the 3rd mistrial, the prosecution asserted that it had decided to retry the case, but was not sure when or by whom. In November 2012, R.G., an eyewitness for the prosecution at the first 3 trials, who identified defendant as having shot Miller, died. Ultimately, 10 different stand-in prosecutors made appearances at various calendar calls from 2010 to 2012 before a prosecutor was permanently assigned the case. Finally, 32 months after the 3rd mistrial, on January 11, 2013, defense counsel conveyed that the case was no longer without a prosecutor and identified who had been assigned to the case. At this same appearance, defense counsel requested a motion schedule to file a motion to dismiss. In opposition to defendant's motion to dismiss on constitutional and statutory speedy trial grounds, the prosecution asserted that the bulk of the delay had been caused by a series of meetings held within the district attorney's office at the request of defense counsel, who sought a dismissal of charges in the interest of justice. The prosecution also asserted the legal principle that delay occasioned by legitimate prosecution efforts to reassess and reinvestigate a case should not result in dismissal, provided that such efforts proceed in good faith and are not deliberately protracted to gain a tactical advantage over the defense, citing Barker v. Wingo, and stated without elaboration that such certainly is the case here. The prosecution further blamed the delay on the practical reality of reassignment of the case to a new prosecutor, who obviously required time to familiarize himself with such a serious and relatively complex case. The prosecution eventually indicated that it was ready for retrial on April 29, 2013, 3 full years after the third mistrial. On that day, the newly assigned prosecutor stated that the prosecution had been ready for trial continuously for 3 months. This is a 6-year-old homicide case. At the fourth trial, the prosecution presented, amongst other evidence, the testimony of E.C. and R.G., each of whom had testified at the prior trials that defendant shot Miller. As R.G. had died by this point, the prosecution introduced his prior testimony by readback of the transcripts from the first and third trials over defendant's objection. The prosecution also presented testimony from a new witness, R.L., who did not identify defendant as the shooter and said he had not made a prior identification of defendant in 2006, contrary to the prosecution's assertions during summation. Specifically, R.L. testified that he saw Miller walking across the street before he was killed and heard gunshots but did not remember who shot Miller. The defense sought to discredit the prosecution's eyewitnesses, calling E.C. and R.G. opportunists and liars during summation and pointing out inconsistencies in R.G.'s former testimony, which could not be explained now that R.G. was dead. The defense also asserted in summation that R.L. was similarly unreliable, had pretty much disqualified himself as a witness, and that any prior identification of defendant in 2006 could not be believed because he was in the clutches of the NYPD at the time and had told the cops what they wanted to hear. The jury convicted defendant on the murder and criminal weapon possession charges. The court sentenced defendant concurrently and imposed a sentence of 25 years to life imprisonment on the top count. The appellate division affirmed. As relevant to our disposition of this appeal, the court rejected defendant's constitutional speedy trial challenge and his claim that the trial court's failure to provide him with notice of 2 jury notes during his first trial required reversal of his drug-related convictions. A judge of this court granted defendant leave to appeal. 2. Constitutional speedy trial claim. Defendant contends that the 3-year delay between his third and fourth trials violated his constitutional right to a speedy trial. In People v. Taranovic, this court adopted a holistic approach to constitutional speedy trial claims, People v. Johnson, citing People v. Taranovic, one that balances 5 factors to determine whether a defendant's constitutional right to prompt prosecution and speedy trial has been unjustifiably delayed. The Taranovic factors apply to both pre- and post-indictment delays, e.g. People v. Reagan, People v. Wiggins. We now make explicit what the court previously implied, namely that those same factors apply to retrials. See People v. Rarbach, concluding that a lengthy delay following mistrial did not violate the defendant's constitutional or statutory speedy trial rights. The 5 factors are: 1. The extent of the delay. 2. The reason for the delay. 3. The nature of the underlying charge. 4. Whether or not there has been an extended period of pretrial incarceration. And 5. Whether or not there is any indication that the defense has been impaired by reason of the delay. Taranovich. No one factor or combination of the factors is necessarily decisive or determinative of a speedy trial or prompt prosecution claim, but rather the particular case must be considered in light of all the factors as they apply to it. Taranovich. The primary responsibility for assuring prompt prosecution rests with the prosecutors. Prosecutors may not needlessly delay without an acceptable excuse or justification, and a sufficiently lengthy, unexplained delay may require a court to dismiss the indictment altogether. Reagan. Applying these legal principles here, we conclude that the 3-year delay to retry defendant a 4th time was unjustified and violated his constitutional right to a speedy trial. While the greater the delay, the more likely the harm to the defendant, there is no specific length of time that automatically results in a due process violation. Johnson, citing Taranovich. Here, the delay was lengthy, more than 3 years, and 1 month between the 3rd and 4th trials, and 36 months between the 3rd trial and when the prosecution declared readiness for the 4th trial. The delay is even more stark when compared to the dramatically shorter time between the prior trials, 6 months between the 1st and 2nd trials, and 11 months between the 2nd and 3rd trials. The reason for the delay factor is critical. Thus, in cases involving post-indictment delays, the prosecution's good faith will not insulate their decision to delay trial from judicial review on constitutional speedy trial grounds. Wiggins. Once having instituted the prosecution has the obligation of advancing it unless there is a reasonable ground for delay. By the time of the delay preceding the 4th trial, defendant had already been indicted and tried 3 times. That indictment remained pending throughout the 3-year delay. Accordingly, the prosecution had the obligation of advancing its case in the absence of a reasonable justification. Wiggins. A lengthy delay demands close scrutiny of the other factors, especially the question of why the delay occurred. People v. Romeo, citing Smith v. Huey. Here, the prosecution's justifications for the delay lack record support and in any case are not persuasive. The prosecution's claim that the delay was attributable to its consideration of defense counsel's request for dismissal after 3 mistrials cannot, without more, account for the 3-year delay. The prosecution did not provide any particular reasons for why its deliberations of whether to retry defendant took so long, given its failure to obtain a conviction 3 times in a row on the murder and weapon possession charges. Nor did the prosecution assert that an internal changing of the guard impacted its ability to render a decision on whether to retry the case. Notably, the prosecution simply did not attend several scheduled court appearances between 2010 and 2013, and when it did, it often could not confirm whether the case would be retried. Indeed, both the court and defense counsel stated that they were unaware of what the district attorney's office was doing for much of this period. Defense counsel further informed the court that the prosecutor was not returning his calls, belying the prosecution's assertion that the delay was due to ongoing negotiations with defense counsel. For example, when the prosecution did not appear at a calendar call on February 28, 2011, defense counsel informed the court that he had not heard from the prosecution. On May 23, 2011, the court referred to the case as a long-running show with no end in sight and explained it was awaiting a decision from the prosecution as to whether it was going to retry defendant. On September 12, 2011, the prosecution missed another calendar call. Defense counsel stated that he had not heard from the prosecution, and the court noted that the trial clock continues to click. Indeed, as of May 18, 2012, more than 2 years after the 3rd trial, the prosecution still had not decided whether to retry the case and which prosecutor would be assigned. On that day, defense counsel stated during the calendar call that he had no idea who was going to be on the case, and the court noted that a couple of weeks before, the prosecution had told the court that it still hadn't made a final decision. The prosecution's argument that it is not solely responsible for the delay, as the bulk of the delay was caused by a series of meetings held within the district attorney's office at the request of defense counsel, who sought a dismissal of charges in the interest of justice, is not supported by reference to any specific meeting dates or even an approximate period during which these meetings were held. The prosecution's cursory statement could be based on meetings during the first few months after the third trial or in the months immediately preceding the fourth trial. It is the prosecution's burden to explain a record showing months of inaction during the 3-year delay. The prosecution further contends that the ADA, who was finally assigned on December 14, 2012, required time to familiarize himself with the case. And yet, on April 29, 2013, the ADA appeared for the first time and stated that he had been ready for trial continuously for 3 months. Thus, at best, on this record, there is a reasonable explanation for only about a month and a half of the prosecution's 3-year delay, from December 14, 2012 to late January 2013. The prosecution likewise did not meet its burden by reference to unspecified reinvestigation efforts. Notably, although at the fourth trial the prosecution put forth some new evidence, the prosecution did not claim that identifying or preparing additional witnesses, such as RL, caused any part of its delay. Indeed, the prosecution only referred to reassessment and reinvestigation in its motion papers when articulating black-letter law, and never made allegations that any efforts to reinvestigate the case in fact caused the delay. Beyond the prosecution's motion papers, the record contains no indication that the prosecution reinvestigated the case before the ADA was finally assigned in December 2012, 2 years and 8 months after the third trial concluded. The prosecution's assertion that defense counsel failed to formally raise any speedy trial objection at any of the prior appearances since the third trial ignores that the prosecution, not defendant, bears the burden to move forward with the retrial within a justifiable amount of time. See Wiggins. More to the point, it is not defense counsel's role to remind the prosecution of this duty. Even in the face of defense counsel's silence, the prosecution must still timely determine whether to dismiss the charges or retry defendant, and then it must take prompt action in accordance with its decision. Admittedly, the nature of the second-degree murder charge might explain some measure of delay. However, this factor does not support the prosecution here, where the preparation to which the people attribute a delay was not complex, Regan, and where the people had already prepared and presented their case 3 times. Furthermore, while defendant's incarceration during the delay was due to another crime, we have been clear that a defendant's imprisonment for another crime cannot excuse the delay. People v. Singer. Such delay may interfere with a defendant's rehabilitation, particularly when they are already aware that they are suspected or known to have committed the other offense, Singer. 3 years is a substantial period for a defendant to wonder whether the prosecution would retry and prevail on a fourth trial, and if not, whether these charges really were a show without end. Lastly, although a defendant need not demonstrate actual prejudice in the face of a lengthy and unjustified delay, see Regan, defendant was prejudiced by the lengthy delay here. Prosecutors may gain a strategic benefit where they can present testimony in the more sheltered form of minutes rather than in the confrontational setting of a personal appearance on the stand, People v. Tapia. R.G. died 2 years and 6 months after defendant's third trial, which necessitated readbacks of his prior testimony at the fourth trial. Reading the cold transcripts deprived the jury of the opportunity to assess R.G.'s credibility in person, diminishing the impact of the defense's attempts to challenge the credibility of one of the only 2 persons to identify defendant as the shooter, R.G. and E.C. Thus, the 3-year delay, during which R.G. died, prejudice defendant to the benefit of the prosecution. While the dissent would remand this appeal for a fact-finding hearing rather than decide defendant's motion today, this approach would unnecessarily prolong this proceeding and give the prosecution an unwarranted second opportunity to marshal facts where they already failed to meet their threshold burden of raising a factual dispute on a material point. See dissenting up at 4-5, citing People v. Gruden, holding in a statutory speedy trial case interpreting CPL 210.5 that a motion may be decided without a hearing unless the papers submitted raise a factual dispute on a material point, which must be resolved before the court can decide the legal issue. Any uncertainty regarding outstanding and unknown facts is a consequence of the prosecution's vague, conclusory, and thus deficient opposition to defendant's constitutional speedy trial motion. The dissent's view of the prosecutor's burden in opposing a motion to dismiss under CPL 210.5 is no burden at all. As we have stated, generally, hearings are not available merely for the asking. Gruden. If the prosecution had provided as much information in their motion papers as found in the dissent, this might be a different case. In sum, based on a holistic assessment of the Taranovich factors as applied to these circumstances, the prosecution violated defendant's constitutional right to a speedy trial. The 3-year delay was substantial, and the record contains only vague assertions of the prosecution's reasons for its delay. Although the serious nature of the charges weighs in the prosecution's favor, this factor's importance is diminished by the fact that the prosecution had already unsuccessfully tried the case 3 times. Additionally, the lengthy pretrial incarceration, as well as the prejudice to the defense caused by the delay, weighs in defendant's favor. 3. Jury notes from the first trial. We reject defendant's claim that the failure to provide proper notice of 2 jury notes during his first trial requires reversal of his convictions on the drug-related charges. Pursuant to CPL 310.30 and our ORAMA protocol, a trial court must notify defense counsel of substantive jury notes so that counsel is afforded a full opportunity to suggest appropriate responses and can seek whatever modifications are deemed appropriate before the jury is exposed to the potentially harmful information. See People v. ORAMA. This requirement ensures a clear and complete record, thereby facilitating adequate and fair appellate review. Here, the record does not establish that counsel received notice of the actual specific contents, ORAMA, of 2 jury notes submitted on October 9 and 10, 2008. Regardless, however, the jury submitted another note on the next day of trial, October 14, requesting, among other things, to hear the same testimony of these same 2 witnesses again. The record makes clear that the parties received notice of the exact contents of the October 14 note, discussed it, and agreed on what would be read back to the jury. Under these circumstances, the error in the court's approach regarding the prior 2 notes does not warrant reversal because the purpose of CPL 310.30 and our ORAMA jurisprudence was satisfied. 4. We conclude that the prosecution's stated reasons for its lengthy delay before the 4th trial insufficiently explain why it took more than 3 years to decide whether to retry defendant on the murder and weapon possession charges. This unjustified delay violated defendant's constitutional speedy trial rights and requires dismissal of those charges. As to defendant's challenge to his convictions on drug-related charges in the first trial, based on the trial court's handling of 2 jury notes, we find no basis to reverse. Our disposition of these challenges renders it unnecessary to consider defendant's remaining claims. The order of the appellate division should be modified in accordance with this opinion, and, as so modified, affirmed. Order modified in accordance with the opinion herein, and, as so modified, affirmed. Opinion by Judge Rivera. Chief Judge Wilson and Judges Troutman and Holligan concur. Judge Singas dissents in part in an opinion in which Judges Garcia and Canataro concur. Decided April 21st, 2026.
Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.